Welcome, everyone, to the Docketing Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Woessner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. There are about 2 webinars per month through May 2017. To see a complete list of webinar topics and to register for future webinars, please go to the Webinars tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the 3rd in this series. Today's topic is Deadly Mistakes, Missing Paris Convention and PCT National Phase Foreign Filing Deadlines, and how to avoid these mistakes. We've allowed time for questions at the end of the webinar. Questions may be submitted using the Q&A button on the control bar of your screen. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation, and then we'll go through them and discuss them at that point. Today we also have a poll. Please take a moment to answer the poll, and we will discuss the results later as part of our conversation about double docketing. The presenters today are myself, Zhakalazky Carrion, and Kristi Wheeler. I am Ann McCrackin, the president of Black Hills IP. I'm a patent attorney with 19 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Izzy, please introduce yourself to the audience.
Hello, everyone. Welcome to our 3rd webinar. My name is Zhakalazky Carrion. I am the docketing manager at Schwegman, Lundberg, and Woessner. I went to law school in Mexico and passed my bar exam there, then moved to Minneapolis and started working at SLW. I've been part of the SLW team for almost 12 years, of which 6 years I've been part of the docketing department and very proud to be part of it.
Kristi, please introduce yourself to the audience.
Welcome. I've been a patent paralegal for 28 years, 23 of those years as a foreign paralegal. I've been with Schwegman for 12 years, 6 years with Merchant & Gould, and 10 years prior to that at a boutique IP firm in Iowa.
Well, thank you both for being on the panel today. Today we'll be discussing the following topics. First, we will discuss why missing a Paris Convention or PCT filing deadline is so deadly. Second, we will present 4 categories of errors or omissions that occur when docketing or de-docketing these types of deadlines. And third, we will offer suggestions and strategies to help avoid missing a Paris Convention or PCT filing deadline. So let's get started. The deadlines we're talking about today are determined by the requirements of the Paris Convention and/or the Patent Cooperation Treaty. For the most part, these deadlines are extremely unforgiving. It's not possible to get an extension for these deadlines in most countries, and it's not possible to revive or reinstate to get a second chance in most countries for these deadlines. So in short, there's very little recourse once you miss a Paris Convention or PCT filing deadline. This can result in irrevocable and permanent loss of foreign rights for all inventions disclosed in an application. And see if we can go to the next slide. If the invention was valuable, the loss of rights could be very substantial, obviously. But if the worst does happen, and you miss a deadline, what are some of the things that you can do, Kristi?
Well, I feel you should always contact a foreign agent in the particular country with your specific facts to see if there is any option in that country that you might not be aware of. For example, after the tsunami, Japan implemented a special procedure to allow for natural disasters. Also, find a country with a holiday on that final date, the 12-month or the 30 or 31-month date. If you find a country, send instructions with the PCT application or your regular application and ask the agent to do everything they can to get it on file. And if it can, they have everything that they need. So no further delays in the application. You may or may not be able to get it, but at least you've tried.
And the idea there being, Kristi, that because the deadline fell on a date that was a national holiday in that particular country, you may be able to file the next business day and still get and still have the application be considered timely filed, correct?
Yes, and I should mention that that country will then boot it up to the IB at WIPO if it's a PCT application, because that country is not a ballot.
Oh, correct. They're not
office.
A competent receiving office. Yeah.
Right.
That's interesting.
Right.
That's a great tip. We're not advocating that anybody rely on a country having a holiday on the date that you were trying to file an application. But if you missed a PCT filing deadline, it can't hurt to try that. Certainly can't hurt. Z, I'll turn it to you now.
So in regards to the Paris Convention dates, I'll explain about that. The Paris Convention Treaty gives an applicant the benefit of the priority date of an original filing in the applicant's home country. Such applications must be filed within 6 months from the filing date or 12 months from the filing date. If it's 6 months from the filing date, it's going to be a designed patent, and 12 months from the filing date will be a provisional or utility patents. There are about 26 countries that are members of the Paris Convention, but not the PCT, such as Argentina, Bahamas, Lebanon, Venezuela. And here we are providing the full list of countries that are not available through the PCT. They can be found in the link provided in this slide, but they are available through Paris Convention. Note that Taiwan is not a member of the Paris Convention. However, by treaty, it does recognize priority claims to U.S. applications. Now, in regards to the Patent Cooperation Treaty, the PCT gives an applicant the benefit of the priority date of an original filing in the applicant's home country and preserves the right to file later in currently 151 countries. PCT applications must be filed within 12 months of the earliest filing date in order to claim priority. So here, the PCT national phase filing dates are as follow. The PCT national phase filing dates would be 30 months and 31 months from the first file priority. So the 30 months would be countries like Brazil, Canada, Chile, China, Israel, Japan, Mexico, Peru, Philippines, Thailand. So Canada and China, you can file extension fees. With the small extension fee, Canada allows 42 months and China will allow 32 months. In China, please note that the full application must be translated at time of filing. This is very important. And for the 31 months, from the first file priority, it would be countries like Australia, Europe, India, Republic of Korea, Singapore, South Africa. So for the full list of countries, just click on the link that's provided in this slide and you'll be able to see all the time limits for each of these countries. There are 4 categories or omissions that can result in missing a foreign filing deadline. Category 1, errors or omissions made in docketing deadlines. Category 2, errors or omissions made in monitoring deadlines. Category 3, errors or omissions made in crossing off deadlines. And finally, Category 4, errors or omissions made in performing a desired foreign filing. So, in Category 1, errors or omissions made in docketing deadlines. It could be wrong priority dates entered for application, common sources of errors, and this can be confusion resulting from multiple priority dates, example, multiple provisional apps rolled up into one regular filing. So just last week, I was working on setting up a transferred in case that had 38 priority claims, and I needed to make sure I used the earliest priority date, and it was not an easy task. That was pretty convoluted. The other thing would be wrong date supplied by filing attorney or paralegal to docketing department. Another example or error or omission would be simple data entry errors. Wrong date entered from another document or communication, incorrectly reading of dates. So if we see in the US, we have month, day, and year. But then in European countries or our neighbor, Mexico, they do day, month, and year. And that can be very confusing when you're doing transferred in matters that you're working from one US priority to a European priority. So you really need to make sure that you're reading the correct dates and entering the correct dates as well. And last, a date entered correctly is later edited or removed, removing the priority date. That's really bad. Docketers should make sure their docketing system automatically recalculates deadlines if a priority date is edited. If it does not, then the dates need to be manually updated. So that's something that you really need to be careful with. Kristi?
Going on to Category 2, the errors of omissions made in monitoring deadlines. Orphan Files, the responsibility for the file is transferred between personnel and the responsibility is not taken up by the newly assigned person. In other words, it falls into a crack. Possibly keeping the old and the new personnel in the system until the new person confirms that they have the date. Maybe the docketers can contact both personnel, the old and the new. Schwegman assigns personnel at the client level. So when a file is opened, that personnel is automatically assigned to the matter, and this avoids any matters awaiting personnel assignment. So a new matter comes in and you don't know who's going to take it over. Immediately you have somebody that is assigned to it. The next is personnel assigned to monitoring the deadline or docket is present at work but fails to check docket and docket is missed. The docketing personnel needs to contact the responsible attorney and a paralegal more than once via email. And if they don't get any response, call those people, find out what's happening to that deadline. The next one is confusion between related matters. Like there are two similar files that get confused in the minds of the monitoring personnel. Just be sure you're talking about the proper matter. And the client, you need to pay attention to detail. Some problems on the similar titles, making sure your filing instructions are clear. You either provide a file number or an application number. That's the best way to avoid that. Especially if you have 3 cases that have the same title. You need an application number or file number. The other one, monitoring personnel is absent from work and no one is assigned to back them up. Always have a backup assigned to you, even prior to any absences. Ensure your backup knows of 12 and 30-month dates that are outstanding prior to leaving on a planned absence. Make appropriate notes in the database and your docket book, and always make sure the foreign agent has acknowledged the filing instructions. Mark your database and docket book appropriately so backup can find what has happened in an unplanned absence. For planned absences, run a docket or a task prior to your absence to ensure you've addressed all the deadlines during the time you are gone. It's really hard to have a backup be surprised by a deadline, and so that will help avoid them. Want to go to the next? Yeah. The errors of omission are made in crossing off deadlines. Instructions from client or coworkers are misunderstood, and the item is improperly crossed off or docketed. And I pretty much talked about that in the previous slide, but the attorney and client may know of the invention by a certain short title that the paralegal's not aware of, so just make sure the application or file number is always indicated. Then client sends erroneous instructions, and it's not necessarily erroneous, but always verify in writing with the client what you understand you will be doing with instructions. For example, a client might say file in Australia, Germany, utility, China, and Canada. Well, what do they mean by utility? Is that a German utility model? Is it a design? If it's a utility application, they're all utility applications. So just clarify what they mean by that word. Clients don't always use or know the correct terminology, so just get your confirmation. Make sure your instructions are clear, and it's basically details, just attend to the details. Okay, and then category 4, errors and omissions made in performing a desired foreign filing. You don't receive your foreign instructions in time. If today's your 12-month deadline and you just get instructions from the client, you can't get countries like Australia, Japan, China, you know, your Asian countries. It's already tomorrow there. Through direct filing, however, you could do a PCT that day to get some of them. Taiwan, you wouldn't be able to get. So also, the paralegal fails to file the application due to distraction or simple mental lapse. That's just attention to deadlines and attention to details. Having your docket department make sure that you know the deadlines. Instructions sent to the foreign associate too late. There again, watch your deadlines. Try to get your instructions from your clients as early as possible.
Zia and Kristi, thank you for your observations on how these errors can occur. It's kind of scary just sitting and listening to you guys talk about all the different ways that a deadly mistake can happen. And as we all know, the potential liability for this type of mistake is very high. So let's talk about strategies and processes for avoiding a missed Paris Convention or PCT national phase deadline. One of the best practices is to double or triple docket these deadlines. And there are a lot of different ways to implement a double docketing process. Zia and Kristi, what are some of the processes for double docketing? Zia, can you start off and talk a little bit about your experiences, and then we'll go to Kristi after you?
So I would say one practice is to use 2 different docketing systems to track critical deadlines, such as Paris Convention and PCT national phase deadlines. For example, in our first webinar, we mentioned a law firm that uses FIP as its primary docket system and CPI as secondary docket for critical deadlines only. One of the advantages, I would say, of using 2 different docketing systems is that each system has its own country law. So if one of the system has an error in its country law, that can be identified by comparing the docketing deadlines between the two systems.
As a responsible personnel maintaining their paper docket, that's what you do. Put it on a paper docket. That should be an attorney and paralegal and or a secretary or administrator. As a primary docket is the electronic docket, like FIP or ANAQUA, CPI, IP Manager, Memotech. In addition to the responsible personnel maintaining a paper docket, office actions should be by the attorney or their secretary, administrator, and paralegal. And for formal documents like power of attorney and assignments, that should be a paralegal and a secretary or administrator. That's one that I do, is paper docket book.
Great. Z, you described, the scenario you described had two different electronic docketing systems in your example, FIP and CPI, within the same law firm or company. A variation of that I've seen is when a law firm or company just has a single docketing system, but they engage an outside vendor like Black Hills IP to maintain that second electronic docketing system. In some cases, they have the vendor docket all of the deadlines, both the recoverable ones and the non-recoverable ones, like foreign filing deadlines. In that scenario, what you effectively have is what I would call a redundant docketing system or redundant docketing department, because both the company and the vendor are doing the same things. So it's redundant, but redundancy is a good way to avoid error, good quality measure. In other cases, the company or the law firm may have the vendor just docket the non-recoverable dates, so the foreign filing deadlines, the things that aren't extendable or things that aren't recoverable. So Kristi, I'm curious what you think is the most important characteristic of a successful double docketing process.
Right. Having two different people adding the deadlines to two different docketing systems, either paper or electronic. And for me as a paralegal, I add a date to my docket book as soon as I become aware of the date. I don't rely on an electronic docket only, because occasionally the docketing department does not receive the documents. For example, even though we ask our foreign agents to copy the docketing department in their emails, sometimes they fail to do so, and I don't realize it. So if I didn't have that on a paper docket, and I docket the final date, and then I have a month prior to that final date, so as a reminder, or the agent may send a reminder, which then I realize, hey, docketing has not had this.
So it sounds like the key is having different people enter the information into different dockets, whether that docket is paper or electronic doesn't necessarily matter. And I agree with you on that. It makes me wonder, though, what can a person do if they have a docketing department with only one person, or they only have one docketing system? How can we have different people enter into different dockets for double docketing? And someone actually asked me that question just a week ago, but they also added the constraint that they wanted the second docket to be electronic. So we couldn't do a paper docket on the second docket, and they didn't have a second docketing system. So we brainstormed a little bit about how they could have a double docketing process with one person and one docketing system. And we came up with the idea of relying on the paralegals in the firm as the second person doing the docketing, an Excel spreadsheet as the, quote, secondary docket. In this case, what we came up with was the docketer would docket in the docketing system that the law firm had, and then the paralegal would review the document as part of the normal workflow and their normal process for handling those documents. And then in addition to their normal process, the paralegal would add the matter number, the document name, the mailing date, the due date, and that paralegal's name to a spreadsheet, and basically log it in the spreadsheet as their secondary docket. Then if that spreadsheet is shared with and updated by all the paralegals, that spreadsheet becomes a secondary electronic docket effectively. And there's lots of different ways that you can share a spreadsheet like that with multiple people. If you have a document management system like World Docs or something else, you can certainly share it that way. If you don't have a document management system, you could use a web-based application like Google Docs or a service like Box or Dropbox or SugarSync to share the spreadsheet. So there's different ways to do it. So these are just a few ideas on ways to double docket. I'm curious to see what our audience does and what percentage of our audience actually does double docketing. So I'm going to have our administrator for this program, Chris, who's been silent in the background, come on. Chris, can you give us the results of the poll?
Sure. In terms of what docketing systems people use, it seemed like Foundation IP and CPI were quite far ahead, with a large number of people using other docketing systems that we didn't have listed. And it seemed like about 75% of people were using a double docketing system, and unfortunately we weren't able to capture whether or not people were using an electronic or paper docketing system.
Okay, thanks, Chris. So, well, that's good that 75% of our audience does have a double docketing process in place, and I think I'm happy to hear that. You know, as we said, there's a lot of ways to do double docketing, but the key is to have a different person enter the information into a different docket system, whether it's paper or electronic, it doesn't really matter. Another best practice for avoiding missed foreign filing deadlines is to verify all of your priority dates that are in your docketing system. And Kristi, can you explain why it's important to verify your priority dates?
Sure. The Paris Convention and National Phase deadlines in this system are all calculated from priority date. So if you have your priority date, even if it's off a day, that could prevent you from getting your 12-month or your 30-month dates correct. The different ways to verify priority dates, if you have your PCT publication, look there or on your WIPO website, see what they claim as a priority, especially on transferred in matters. And the publication tells the priority story. It can be trickier if the file is received earlier than publication. But if it is earlier than publication, then you can look at the request form, or if you have at the application, many previous counsel may have put that priority information in the first paragraph of that application.
Great. So you can also verify priority dates electronically. And in our last webinar, we talked about techniques for verifying data in general, and that could include priority dates, either manually or by electronically comparing the dates against another source, such as PAIR or Impedoc. That webinar was called IP Management System Data Integrity. If you missed it, the slides and the audio from it are posted on our webinars tab of our website. Finally, I can't emphasize enough how important it is to only use paralegals and docketers who are proven to be exceptionally reliable.
Now, I have something to add here. Ann and I worked together at SLW for several years, and then Ann started with Black Hills. We ran into each other after a while that she was at Black Hills, and she said, so docketers are pretty important. They just can't be anybody off the street, which, true.
It's funny, Kristi, I'd forgotten that, but that's absolutely true. And certainly the docketers at Black Hills IP are definitely not just anybody off the street. They're a very, very important part of the process. Z, let's go to the next slide. Another way to avoid missed foreign filing deadlines is to make sure deadlines are removed from the, to make sure deadlines are not removed from the docket incorrectly. So Kristi talked about what we labeled category 3, the cross-off errors. And in my opinion, one of the most difficult docketing errors to detect is something incorrectly removed or crossed off from the docket. So some of our tips and strategies for avoiding a cross-off error, and particularly a cross-off error for a foreign filing deadline, is to have at least 2 people be responsible for the cross-offs of those critical deadlines. For example, you could have a person in the docketing department who does the cross-off initially, and then either the responsible attorney or paralegal then verify that the date that was crossed off was in fact supposed to be removed from the docket as a double check. It's also a good strategy to have all cross-offs of critical deadlines, including these foreign filing deadlines, be verified in writing by your client. I know that was certainly my practice at Schwegman, particularly when my client would ask me to or instruct me that they were not going to file any international applications, and I was having the docketing department take that foreign filing deadline off the docket. I would verify that in writing with the client just to make sure and confirm. And although this last bullet doesn't relate specifically to cross-offs, it goes more to what Kristi called the category 2 errors, which were errors in monitoring deadlines. And that is, it's a good docketing process to have your docketing team send reminders to the responsible personnel the day before the foreign filing deadline as opposed to the day of. Because as Kristi, I think, noted before, in countries like Australia, China, Korea, that day's already passed if you're getting the reminder on the actual day of the due date, and it may be too late to file in some of those countries. So having reminders be sent the day before is another good practice for avoiding missing these types of deadlines. Then, continuing with the strategies and processes for avoiding these foreign filing misses, the next area to look at is how you manage your clients and how you handle the process to get filing instructions. It's really important to make sure you give sufficient notification of the upcoming foreign filing deadlines to your clients, and that you request receipt of instructions as early as possible from the client. So, Kristi, can you talk about best practices with respect to notifying and obtaining instructions from clients?
Sure. We aggressively notify the client and monitor the due dates so the client has plenty of time to make decisions and get us instructions early. We call the client, call the attorney, call the U.S. paralegal. If we're within, a week of it, we send reminders at 6 months, 9 months, 11 months, and again, weekly, trying to get those decisions. We make it clear to clients that you can't be responsible for filing on time unless instructions are provided at least 2 weeks in advance. That's basically just keep on the client and asking for instructions.
Good. And then once those instructions are received, it's also important to make sure that the right people get the instructions. I know at Schwegman, for example, Kristi is a foreign filing paralegal, and there's a separate paralegal that handles the U.S. work for each client. And, if you think about the 12-month deadline following a provisional, it's not just a foreign filing deadline, but it's also the deadline for filing the regular utility application. And if there's 2 different people that need that information, make sure that information, those client instructions, are properly conveyed to everybody that needs that information, right, Kristi? Right,
and if you're unclear who needs it, just send it to everybody. Somebody will pick it up.
That's good. And then in the instance where you have a foreign file, or you have a provisional filing and you're looking at a 12-month deadline off that, don't forget that that 12-month deadline is not just the deadline for the U.S. utility and the PCT, but it's also the deadline to file in any of those non-PCT countries that Z talked about. And Z had the link at the beginning of this presentation, which gives you a list of all the countries, Taiwan being one of the notable ones, that are not members of the PCT. So that 12-month date after the provisional filing is also the deadline for those direct filings in countries like Taiwan and Argentina and the other ones on Z's list. Also, I want to make a note. Chris said a lot of our users use the foundation IP, or our listeners use the foundation IP system. As some of you probably know, foundation IP can docket a second 12-month foreign filing deadline in the scenario where you have a provisional application followed by a U.S. utility. Foundation IP can docket a second 12-month deadline for foreign filing following that utility application filing date. And I often get questions about why does Foundation IP do that? And the answer is, oftentimes a provisional is a bare bones application, and there's a lot of new substantive material added in the utility application that could be the subject of a PCT application as well, and for whatever reason maybe was not included at the time that the utility application was filed. You can then docket a 12-month date, and Foundation IP has the ability to do this, docket a 12-month date following that utility application to do an additional foreign filing for that new substantive material that was in the utility application. Now, in order to get Foundation IP to do this, you have to make sure you are using the correct case type when you set up that utility application. And there's a difference between the case type NP-REG, NP-REG, and NP-NEW, NP-NEW, in Foundation IP. And Z, you're the docketing expert here. Can you explain the difference between those two case types in Foundation IP?
Yeah, sure. I'll keep my difference simple and short. NP-REG doesn't launch a 12-month foreign filing deadline, and the NP-NEW does launch a 12-month foreign filing deadline. That's it.
Okay. Thank you, Z. All right, let's say the absolute worst happens and you miss the foreign filing deadline. How can you mitigate that miss? Well, first of all, if there was no prior disclosure, so you have no absolute novelty bar, you can still file your international applications without a priority claim. But that, in many cases, is not the facts that you have, and that's not the scenario. So what else can you do? Well, double check the time limits for PCT national phase applications in the countries that you're interested in. That should be the next thing you do. So Z talked about the fact that some PCT countries allow 31 months to file, others are 30 months, some even you can go out to 32, and in fact there's a few that even allow extensions. So Z gave a link earlier in this presentation that's a great web page that has the list of all the countries that are 30-month countries and 31-month countries. That's a great resource to check. In addition, Z mentioned extensions. I think you gave the examples of Canada and China being countries where there are extensions. So there's a few countries that allow extensions for those PCT filings. And then, Kristi, you were telling me when we were preparing for this webinar about a scenario in Europe that involves the process for their notification of loss of rights. Can you explain what you told me to our audience?
Sure. During the PCT phase, the European Patent Office assigns an application number to that, a European application number. If they see that 31-month date has passed and that application number has not entered into Europe, they will send the notification. It's called a Rule 112 Paren 1 notification directly to the applicant, not to your agent, but directly to the applicant, indicating that they have lost rights. And in that notification, they set a 2-month deadline to file Europe. There is a 50% surcharge in it, but if your agent didn't do something, your attorney didn't do something that the applicant feels that, hey, I wanted, or even if they say, I just wanted Europe, we decided late, you still have that opportunity to file. It's about 36 months. And then, of course, Canada allows a 12-month extension, so it gives the applicant about 42 months to decide on Canada as well.
Good. And then there's also some cautions when you're talking about Europe with respect to being able to enter countries directly versus through the EPO. Can you talk about that?
Yes. Europe has 38 member countries. They call them states. So of those 38, 12 of them have closed the direct or PCT route. So you can't go directly into that country from a PCT. Some notables are France, Belgium, Greece, Italy, Netherlands. If you want to go directly into those countries, you should do it, and don't want to file Europe, you should do it at the 12-month Paris Convention date. If you know what countries your client is interested in, and they're only interested in 2 or 3 European countries, you might want to look at the 12-month Paris Convention deadline, and especially if one of those is one of those France, Netherlands, whatever. Because again, if you go to PCT and file, you can't go into those directly. You have to file a European application, and those are quite expensive if you're only wanting 2 countries.
Okay, good. I also want to mention, and this is a very, not a very common scenario, but I'll mention it, where your application that you're working with is a continuation in part, and meaning that it has 2 filing dates. The first, or it has content that have 2 different priority dates. So the earlier priority date being the date for the first invention, and then a second priority date being the date for subsequent material that was added to the continuation in part. If you missed the foreign filing deadline that was based on the earlier priority date, you might be able to file a international application based on the later filing date, assuming that the material in the CIP, the newer material, was substantial enough to be worth that particular filing. And obviously, you'd only be able to get the benefit of the priority, the later priority, and that would apply to the later new material. So these are all things to keep in mind. And then don't forget that tip, Kristi. I thought that was a great one, that if you happen to be lucky enough to have a national holiday in a PCT country, Kristi's tip that maybe you can try to get the application filed the next business day in that particular country. Again, we're not advocating you rely on that, but it's just another tip and thing to keep in mind. So, we've talked today about why you might, why missing a Paris Convention and PCT filing deadline can be so deadly, and what are some of the types of errors or omissions that can lead to missing one of these deadlines. And then we spent quite a bit of time talking about strategies and processes to help you avoid missing Paris Convention and PCT deadlines. Now I want to remind the audience that questions can be submitted using the Q&A button at the bottom of the control bar of your screen. We do have some questions in the queue that I will start working through, and if you have a question you have not entered, please add it to the queue, and we'll take some time here to go through your questions. The first question is, how do you address the time difference between countries? And that's all I have in the question. So Angela, I'm assuming what you mean is possibly, because this was submitted earlier in the presentation, about the fact that if I have a foreign filing deadline today, October 12th, I really needed to have that deadline reminder yesterday because it's too late now to file in some of the countries like China, Japan, Korea, Australia. So it's really recognizing that and doing your reminder process early enough that you can take into account the time difference between countries. Z or Kristi, is there anything else that I might be missing on the question about how do you address the time difference between countries?
No, I think you said it. I think always try to work ahead of time when you're working with China, Japan, or pretty much the Asian countries, know that time difference and work a day before or even two. It doesn't hurt.
Correct.
Okay.
I agree.
The next one is, I am in a very small firm and use Patsy for docketing. I don't use a double docketing system. The firm would not use a second docketing firm. Would just adding deadlines to the calendar be suitable enough? Well, we talked about anything as a double docket is better than nothing, right? So that's again, it's better than nothing. It's a good practice to have. My initial thoughts, and I'll let Z and Kristi comment on this as well, are I'd be a little worried about those dates on your calendar getting mixed in with other things. If you're putting it just on, let's say, your Outlook calendar where you have your meetings and everything else, I would suggest that you set up a separate calendar that is just your docketing deadlines calendar if you're going to use that as a double docket. Kristi and Z, anything you want to add on that?
So I've been here at Schwegman, a case management assistant, a paralegal, and a docketer. And in all those three different positions, I've always had a docket book, a special calendar thing where I add all of my deadlines and don't add any extra stuff to it. I use a lot of different colors too, so I can see what is my main deadline, and I go with that. I wouldn't go with Outlook. I would just have this special docket book calendar that you can rely on as soon as you find out about a document or an office action or a PCT national face deadline or a convention PCT deadline. I would put it in that docket book. That would be my way of reassuring myself that I am adding any deadlines that I am aware of, putting it in there, and then add reminders as well.
That's a great point, Z. And just Kristi, let me jump in and I'll let you go. I made the assumption when the question said calendar, I was thinking like an electronic calendar, but it doesn't necessarily have to be. And you guys at Schwegman use a paper docket book that is just a day planner, basically, right?
Yes, correct.
Okay, good.
I was just going to jump in by we talked yesterday about the red book and having one specific case. If it's a small firm, you could have one book put in a general area so that everybody has deadlines, can add them to that book. So, but I also really stress each individual person having their own, be responsible, but as a firm, maybe having another written one just by simply a binder or something like that. Good
feedback. The next one is, can you address how receipt of instructions for filing or non-filing plays into filing and not filing, and the risk of receiving instructions at the last minute? Also, how to communicate with the client to express the importance of getting instructions early. So, Kristi, you talked about the getting instructions early, the being diligent, being asking multiple times for instructions. How do you do those communications? Are there anything that you found that are particularly effective in doing that? And then also and comment on the last minute thing too. What happens when we get them, but we get them at the last minute?
Well, we try to get them filed, but anyway, I'm calling the client. I'm emailing mostly because at Schwegman we do mostly but emailing. But if we don't receive instructions, I'm calling the attorney to find out, you know, are you going to contact them, or do you want me to contact them, or just proactively saying, we need these instructions now. And but making a call, sometimes those come at the very last, you know, the day before the deadline. Man, I'm out there getting the instructions to the agents, you know, or if it's a PCT file, just send the PCT and say, here, file this. Our formal information will follow. You know, and hopefully, I'm assuming that you would have a group of your normal associates that can take it up, and you know, and can respond, or you know that they're going to respond appropriately. But there is always the risk that they're out as well on holiday.
Mm-hmm.
So, and you need to know that too, is like, why am I not getting a notification that the agent has received these instructions? Well, they might be on holiday, which is fine for them. Make sure that, because they will get the next day. So, but you know, just keep on the client to get those instructions.
Z, anything else on that?
No, I think she covered it all.
Okay. Next question is, what about filing a continuation with new claims years after priority? How do pure continuations for new claims I think that's translate to other countries? You know, on questions that are specific to how something will be handled in another country, I always, in my practice, have relied on contacting an agent in that particular country. I've never tried to be a expert in anybody else's country law. So in that instance, I would, if that's a scenario where you think you might have, I haven't done that myself personally, but that's a scenario where you think you might have, I would contact an agent in the country where you want to file to see, before you invest the time and the money into it, to see if that would actually be a scenario that would work.
I totally agree, Ann, because, I mean, always ask the question. You never know what the answer is. The agents might have a good strategy that we don't know about. So always ask your agents.
Good. Let's see. Here's a great question. I wish we could have a poll on this. Should attorneys maintain their own secondary dockets? So you have on the line, I'm an attorney. Kristi and Z are not. So let's see what Kristi and Z say.
I say yes.
I totally agree. It doesn't hurt. Don't leave it all to your paralegal or your secretary administrator. You need to be responsible for your dates as well. And then you can work ahead of time too, when you know that you're going to have a PCT convention deadline, a Paris convention deadline, or a PCT national face deadline. That's me.
Totally.
And I'm on the same side as you guys. I agree with you as well. I think that it's ultimately the attorney's responsibilities for these things, and it's a team approach and a best practice for the attorney also to maintain that docket, whether it's just simply a calendar entry in your Outlook or it's on a paper docket book in your day planner, whatever it is. Everybody's got their own method, but the attorney should also track their own deadlines. That's definitely a best practice.
And you know something that you said?
Yeah, go ahead.
And sorry, I just wanted to say that you mentioned team. And when we're working with these, it's not only one person's responsibility. If you work as a team, you will have a better product too. And your product would be filing that application on time. So working in the patent side and working as a docketer, everything works out better if you work as a team and not just think that one person is the one that has the responsibility.
Correct. And
Sure.
docketers and paralegals aren't going to get sued if the attorney doesn't do the job. Just had to throw that in. Sorry.
And docketers and paralegals don't have a license to lose, right?
That's correct.
So, okay, now I have another one. It's a little more complicated, and Z and Kristi, I think you guys can read this one from Mark. My U.S. patent attorney filed the PCT national phase with 6 countries. So we filed national phase in 6 countries and has come back with additional billing from some of the countries, but it sounds like not all. Should my U.S. patent attorney provide me with the invoices, meaning should they give a paper trail back to the paralegal or docketer, currently being sent an amount to be paid in the email? Oh, okay. So the attorney's just telling them how much is being paid, but not giving the actual supporting documents back to the attorney or paralegal. So the question first is, how much documentation or paper trail should the attorney give back to the docketing or paralegal? And then second, where can I go to check the national phase fees were actually paid and that the national phase filings are actually in process?
I think
Dear
I can
Kristi,
answer
do you
that
have
one.
any information on that one?
Yes. First of all, you can tell your U.S. attorney that you're not going to pay him until you see the invoices. I mean, he's supposed to be working for you. Also, as far as where you can go to check the national phases, go to the WIPO website, wipo.int, I believe. And they have a section. You need to find the PCT section of that website. But and maybe we can add that to the webinar, where to find, what the WIPO website is for PCTs. They have a tab there talking about national phases, and the agent or the countries that have entered national phase normally go into that update. That information is updated on the website, so that should be available to you through WIPO.
Good. Well, and I didn't even know that, Kristi. Thank you very much for that. I appreciate that. Another question, will you be presenting any prosecution-oriented webinars in the future? I'm assuming you mean this, Alyssa is asking about docketing, prosecution docketing. And yes, if you go to our webinars tab, for example, November 30th, we have common U.S. docketing mistakes and how to avoid them. December 14th, we have best practices for docketing optional U.S. prosecution interviews and appeal procedures. And there's a number of other ones too that are prosecution oriented. So definitely, and take a look at the webinars tab of our website. Julie says, can you talk a bit about incorporation by reference, when to use this, and what are advantages and disadvantages? From a docketing standpoint, I think that's a difficult question to answer, Julie, but thank you for it. I know you're getting into whether you have support in the specification for certain things, and that probably also applies to then priority dates. That gets more into the substance of the application, and I would refer you more on that question to an attorney to talk about the advantages and disadvantages. Zia or Kristi, have you dealt with incorporation by reference in the context of docketing, Paris Convention, and PCT national phase deadlines?
Not as far as docketing. I believe if you miss a part of your PCT application by claiming to incorporate it by reference, I believe you can, some countries allow that, but I'd have to go into and kind of study that again. Yeah,
and it gets into kind of the substance of, is that a, whether that was a, and I forget the terminology, but whether it was a critical part of the disclosure or just more background information too. So that one I'm not going to be able to give you an answer on this webinar, unfortunately, but it's a very good advanced question.
Before we go on, Anne, it just kind of brought to mind that, your PCT application, if you quickly file it, you may forget some part of it. You need to really check to make sure what those documents are. If you're sending drawings, if you've completely forgot your drawings and you're going to send drawings, say, here, add this, WIPO will give you, or you'll get a new filing date, and that might be after your Paris Convention deadline. So you need to make sure that those drawings are imperative to get, and see what you're going to lose in that application. I just thought of that.
So the best answer is don't have to rely on the incorporation for anything, because that may mess up whether you have met your filing deadline or not.
Well, it could help if
Okay.
you miss the drawings, but,
Yeah.
for the countries that allow that. But
All right, well, I think we've covered the questions that we have today. This has been a great list of questions, and I thank all of our audience for asking good questions and staying on for the whole program. The next webinar in the Docketing Excellence webinar series is on October 26th at 1 p.m. Central. The topic is options and best practices for docketing prosecution for corporate IP departments that outsource prosecution. To register for the webinar, go to the Black Hills IP website. Thank you everyone for participating today. We hope you will join us for this and other webinars in the Docketing Excellence webinar series.